Hello, everybody. Hello, Princess Ava.
All right, the next case is James Dash and Rebecca Degrees. That's file 25-40752-LT. Mr. Blumberg.
Good afternoon again, Judge. Elliot Blumberg on behalf of the plaintiff, James Dash.
I do see Ms., is it Degrees, or how do you pronounce your last name, ma'am?
Good afternoon, Your Honor. It's Degrees.
Degrees, all right. Ms. Degrees is here as well. This is a first hearing on a landlord-tenant matter. Mr. Blumberg, how do you wish to proceed for the plaintiffs?
Judge, so the record is clear, Mr. Degrees was a tenant as a guest of my clients in a home that they had once resided in. There was a mediation agreement signed by the parties that required Mr. Degrees to vacate the property on March 31st of 2025. She didn't do that, hasn't paid rent since then. We are ultimately seeking an order of possession. We would like her evicted from the property.
Ms. Degrees, your response?
Good afternoon, Your Honor. There are many nuances and there are additional pending charges against Mr. Dash. I did submit an envelope with 2 letters to yourself for your reference, if you would be so kind to review that at this time. It's difficult for me to talk about.
Have you sent,
so I
have you sent that information? I'm sorry, I didn't mean to interrupt. I do have an envelope, but I haven't looked in it yet. Did you send the same information to Mr. Blumberg as the attorney for the other side?
No, but he's aware of all of the things, you know, for the last 2 years.
Typically, as a judge, I'm not supposed to look at things from one side where the other side doesn't know what the judge is looking at. It's called ex-parte communication. I can talk about those things in court when both parties are present, but if you want me to read things, they have to be decided whether or not they're admissible or whether they're improper for me to look at. And the only way for Mr. Blumberg to know about that, to object if there is an objection, is if he has that information ahead of time. Do you believe, and again, I haven't looked in here and I'm not going to today, but do you believe that there is a basis for you to stay in the place based on the materials that are in this file?
Absolutely. I believe there's several reasons. While I am not,
are there legal reasons?
I'm sorry.
Not just because you want to. Are there legal reasons why you should be allowed to stay?
Well, that's why I wrote it all down. It's hard for me to express myself in the moment just from the traumatic nature of the relationship. It was a 10-year relationship and the house was, I don't know if you can hear me or if it's like, because I have maybe a disconnect on my side. I do apologize.
No, we're good. Here's what I'm going to do. I'm going to direct you to send everything that was in here to Mr. Blumberg, a copy of it, so that he has an opportunity to review it prior to me looking at it. I'm going to reschedule this matter, which is typically what I would do anyway. Typically on a first hearing, it's a chance for me to understand what the circumstances are. And then if there's going to be a contested hearing, I have it at the second hearing, which will be in about a week. So that gives him an opportunity to object if he thinks so. That also gives you an opportunity to collect your thoughts. And then if there's something in the file that I need to review, I can do it at the next hearing. Do you have any problem with that procedure, ma'am?
Well, I just would like to make a note. I was not aware that you could not review it. Our shared minor child and I live in the home. So I'm sorry. So it's just very difficult. Like, can we still live in our home, or there's just been.
Well, all I can say is, all I know about the situation is what Mr. Blumberg has filed as the complaint, and he says that there was a mediation agreement as part of what looks to be a divorce case that says that there was an agreement that you got to stay in the home until a certain date. And now that date has passed and they want you out. So that's all I know at this point, because that's all that's been presented to me. So I can't make a decision on that, and I won't make a decision on that today, but I will make a decision on that at the next court date, unless there's some really good reason to adjourn, which I can't think of at the moment. So you may need to make preparations one way or the other, because I'm going to try to make a decision one way or the other at that next court hearing. Mr. Blumberg, typically it would be approximately a week from now, which would be July the 7th. We have time on July the 7th for a contested hearing. Let me check on my court staff first.
Yes.
So it looks like we do have time for a contested hearing on July the 7th. Ma'am, do you have any objection to having this hearing on July the 7th? That'd be a week from today.
I do not. I just, sir, if I may say, like, well, I am not, well, I do not have a degree in law. I am working on my master's in education. I am certified by the state to teach law to high school students. And I did quite a lot of research into family law. And there are several items of note that are in bad faith on Mr. Dash's part.
You're going to have an opportunity to tell me all that stuff at the next court hearing then, if that's where you want to go with this. But I can't make a decision today if Mr. Blumberg hasn't seen the information that you want me to see, because he's entitled to that. You understand what I'm saying?
Oh no, I very much comprehend what you're saying, sir.
Anything that you want me to consider for next week, and if it's in here, you need to send all of that to Mr. Blumberg. I'm not going to look at it until then. And if you start talking about it next week and Mr. Blumberg hasn't seen it, I'm going to say, sorry, I can't consider that, because he's entitled to look at all that information. Do you understand?
Yes, sir.
All right, Mr. Blumberg, any objection to next week?
No, Judge, if that's how we're going to proceed, that's fine. I'm acting in good faith that she will provide me whatever it is she gave to you.
Well, and I've told you what will happen if she doesn't.
I agree.
You're protected and she's protected. She's going to have a chance to talk about it. If she doesn't provide it, then she doesn't get a chance to talk about it. So any other questions that you have, ma'am?
No, I just would like to say one thing. The reason I have written it all down is it's very hard for me to remain composed due to like various criminal actions on Mr. Dash's part. So
then take a lot of notes and prepare yourself to be able to talk in court.
yes, sir.
All right, that's all for today. Then I'll see you both next week.
Thank you.
All right, this is Elizabeth Hostman versus Joseph Walsh and Christine Dean Walsh. Parties want to come up and have seats at the tables, please. All right, I have Ms. Hostman along with Mr. Serino. Mr. Serino, you're acting as her, what is your position with her?
Property manager.
Property manager. And who do I have on this side, sir?
I'm Joseph.
Joseph Walsh.
Yes.
All right, ma'am, your name is?
Kristen Walsh.
All right, so I have the plaintiff and the defendants both present. Typically, court cases go in a prescribed order. I'm going to hear from everybody, give everybody a chance to tell me what their side of the story is. Typically, I would hear from the prosecution first, just because that's the way that the process works. And then I would hear from the defense. And then if there is a need for, so I'm going to hear argument, or at least a summary of what you think the case is first. Then if we need to take evidence, I will swear in the parties, and typically you can talk right from where you're at. Once you give testimony, you're subject to cross-examination, which means that the other side and or I as the judge can ask you questions to make points. If you want to give me documents, typically one side can do that. They have to show it to the other side first so that you know what it is and you can object to it if you need to. And then I typically need to hear from the person who wrote the document or the person who has knowledge about the document. I can't have a document that says Joe Blow said this, unless Joe Blow is here to authenticate that sort of thing. So any questions about the procedure that we're going to use from either side? All right. Ms. Hostman, why don't you tell me just kind of a summary of where we're at? You can either do that or you can have Mr. Serino do it, whichever you prefer.
Basically, we're at a point where I'm trying to fix things at the house, and he doesn't want anything fixed until after this hearing, and that's fine. But we have been lenient with the Walshes. Joe had some health issues. He asked for me to work with him, and I said I'll be happy to do so because he was going to go for disability, and we waited patiently for that on the premise that he was going to pay us in full when he got it. And I talked with my client, and she agreed to let this happen. Joe asked me to work with him, and I did. Unfortunately, that he never did pay that off. So that's how the major amount of that $10,000 came about. Later, after he started paying, he unilaterally decided that he was going to pay. They were going to pay $200, and he does. That's not really at $10,000, $200.
So the 200 was for the rent, or was that above and beyond the rent for the amount that they owed in the past?
Exactly.
And they passed.
Okay. And 10,000. That's a long time. So I wasn't happy with that, and I even talked to Mrs. Walsh about it, and to try to get it up a little bit, and instead of raising it to an amount that would be meaningful, they paid less and less. And the last time they only paid $500, and I advised my client that we just can't do this. I mean, we're not going anywhere, and that's when we filed for eviction.
Okay.
We're hoping to get a judgment. We're not. Mrs. Horsham is not necessarily trying to evict the people. I've also told the Walshes that we're not trying to evict them. We just need to get $400 a month over the amount. It's only $720 a month, which is extremely reasonable rent these days, and so that would bring it to $1,120. But that would be a meaningful amount towards the arrears. That's what we're seeking on.
All right. Who wants to speak for your side? Go ahead, man.
I guess
I'm sorry.
Go ahead.
I sent it to Mr. Serino, a message, and I do have it in writing, and I printed out the text also. Letting him know that we're not disputing the amount that he says we owe necessarily.
So he says, I think in the complaint was $10,030. Does that sound about right? Okay.
I think I've been through most of the receipts. The statements kind of confused me only because the past due amounts that I paid got recorded, didn't get reported on the months that they belonged in. So that's what confused me with that. I had found one payment that hadn't been recorded, but that was repaired.
Okay. So what is it that you think is still owed? Is it the $10,030?
I'm really not going to dispute the amount right
Okay.
now.
All right. So what is it that you?
Okay. Now, I think there's some misunderstanding with Mr. Serino thinking that we received a large lump sum. We received, I believe, $5,000 from Social Security.
I don't.
No, hang on.
Not even time.
Well,
Not
let's
even-
slow down.
Yeah.
This isn't negotiation time. If you guys want to negotiate, I'm happy to
No,
send you into a room and have you negotiate.
No.
But all I need to know is they told me what their side was. I need you to tell me what your side is. And then if I think that negotiations would be more appropriate than me deciding, I may do that. But what I want to do right now is just get your side of it. Okay. So go ahead, sir.
When does his neglect and negligence come into this?
that's,
If you want to present defenses, then we can talk about that. So tell me what it is that you want to do. This is your kind of summary of what it is that you think should happen. He's told me what he wants to do. He wants to keep you in the place. He wants you to pay about $400 a month over your rent amount. And so you can tell me, all right, we want to leave. We want to stay. We want to pay this. We think that's a reasonable basis because of this. So tell me that summary.
Okay. I told him in the message I sent him that there was no way that we could stay in that house due to the mold. I had mold testing done. Um, every wall, the roof is no good. Every wall is saturated. I had Servpro come in and do moisture readings, with this mold testing, like I said. It's not livable.
When did that start? You said it's not livable, but you're still there, right?
Yeah.
Okay. So how long have you been in? Are you still in the house now?
Yeah, we're still in the
All right.
house.
But are you saying to me that you want to get out of the house for a period of time to let him remediate the mold, and then you want to see whether or not you go back into it, or what is your pleasure?
I really can't do it.
Okay. So you want to be done. You want to leave the place.
Yeah. We want to.
Okay. So when do you want to be out?
Yeah, we need a little more time.
Well, typically 30 days. Well, if there was a judgment today, if Mr. Sereno asked me for an eviction judgment, you'd have 10 days. That's what the law says in Michigan. So if you want to get out, 10 days is the normal. If there's some reason to vary from that, I'm willing to listen to it. But if you're saying we want to leave, you can leave. There's no problem about that. But then there's a question of how much do you owe for the time that you actually spent in the house? And you said $10,030 was what it was for back rent.
Okay.
Okay. Is there anything else that you want to tell? Let me talk to her first, and then I'll talk to you, sir. Is there anything else that you want to tell me, man?
No. There's extensive mold throughout the entire house. Since the snowstorm, we have been without power in the east side of the house, which I've mentioned a number of times. And
So the east, pretend I don't know about the house.
Okay,
The
I'm
east
sorry.
side of the house doesn't tell me. Okay, so is that half the house?
that
Is
would
that one room?
include the living room and the two back bedrooms, no power. That's since that.
So the ice storm is the end of March.
No, this is the snowstorm.
Oh, okay.
This was started January 30th. That's when that power went out.
Have you let him in the house and try to fix that?
He didn't come to the house. He hasn't been in the house since they replaced the hot water heater, and that was.
Okay. Did you send notice to him that the electricity was out?
Yes.
Okay.
Yes.
Got that. So what else? What other issues do you have?
Then after the ice storm, when they finally got the power back on, none of the outlets in the kitchen. So I don't know about that. And I do have copies of text that said that he was sorry. He would get us moved out into a different place.
When did you send notice to him that the kitchen outlets were not working?
With the tissue comment?
No, that
was the-
snowstorm.
Yeah, that's the back room.
Can you give me an approximation, even if you can't come up with a specific date?
I told him once when he came into my place of employment.
Approximately.
That would have been.
So April or May sometime?
Well, actually, when he came in to serve me with papers, I told him.
Well, this was sent out in May. The original certificate of demand for possession was
Okay.
dated May
So
13th.
that would have been after the ice storm.
So you think approximately in May sometime? Or are you just not sure?
He got two sets of papers.
All right, that's fine. That's fine. So tell me what else, what other issues that you have?
Okay, I've got pictures where water comes up through the floor after it comes down through the walls,
The floor of what room?
the living room.
And did you notice, did you give notice to Mr. Sereno then? When was,
Yeah, we sent him pictures by text.
when was that?
This would have been February 2nd, so this would be going back to the snowstorm.
Okay.
And stuff
But
started to
it's,
melt.
Yep.
yeah.
What other issues do you have then?
During the ice storm, we didn't have power for a while, and that's fine. Most of the neighborhood didn't.
Yeah, most of your neighbors did.
And then the rest of the neighborhood got power back on. We still didn't have power.
3 weeks.
Yeah. Is there something that Mr. Sereno did or didn't do that caused that, or was that simply the ice storm?
I guess that would be a matter of opinion. Yeah, the first company that came to replace the pole that was broken wanted to come inside the house and do some work in the house, and I don't think that was kosher. I don't speak to his side of that.
What, I don't understand what you're telling me.
He just wanted them outside to fix the pole. Yeah.
Okay, so there's an issue with power
Yeah, it's the place
after
is
the ice storm.
built in 1963. So the
All
power
right.
inside is.
Okay, so any other major issues?
Oh, I have pictures. That you can both look at.
Pictures about what? Same things we just issues with.
The state of.
Okay, so right now I'm just trying to get a feel for what's out there before we get into actually who's going to prove
The
what.
ceilings are all sunken in. The cabinets are not even sitting correctly on the walls anymore because of water damage.
So all of that to say house is not habitable. Okay, so what do you want to do about that? Sir, do you have anything else to add? Any other issues to add to that?
I'd have to go back through all of it from the start. If you want me to take 2 minutes, should I stand up?
All I want to know is a summary. I don't need your testimony at the moment. I just want to know what in general are your claims. Is there anything that your
When the
wife has
power
not
in
said?
that back room went out, I told him it blew and it keeps blowing fuses. He told me to take a piece of tissue paper and put it in the socket and then turn the power back
Okay,
on.
sir, you're misunderstanding what I want to talk about. I want to know what are your claims, not individual proofs of what he did or didn't do. I want to know what in general are the claims that you want to say that the house is not habitable. So the things like there's no power on the east side, the kitchen cabinets or the kitchen outlets aren't working. There's water in the wall and the floor in the living room. There was no power for a period of time after the ice storm because he wouldn't let the power people come inside. And the ceilings are sunken in and the cabinets are on the walls because of whatever. There's mold in the house. Are there any other issues like that you want to bring to my attention?
Well, the hallway and the bathroom hallway sags down in the new
Is that the
floor,
floor or
which
is that the
I installed.
walls in the hallway? The floor or the walls?
The floor. It sags down when you walk on it. The inspector came, and that was one of his main, oh my gosh, when he was there.
Okay. Any other issues like that? Okay. So now that I know what the main issues are, now I need to know, he's told me what he wants to do as far as the big picture. He would like to have you guys stay in the house. He would like to have a chance to fix those things, and he wants you to pay your rent plus $400. What do you want to do by way of big picture? What's the end game here?
Um,
Sir?
We want 60 days to move out. We have an estimate to clean all of our property from Servpro for the price of cleaning all the mold out of that. And we want him or her to cover that. The cleaning of all of our stuff from the mold, because the mold is a prairie mold and it emits toxic whatever.
Okay.
The mold
Do
itself.
you have documentation from Servpro?
Yes.
And do you have a witness that will be able to say all those things
Yes.
today?
Today, I don't.
We've got her written estimate and what the stuff
Okay.
that's
Have you
wrong.
given that information to Mr. Sereno?
No.
Okay. See, here's the problem. When you keep stuff close to the vest and you don't give it to the other side, they can't make decisions about what best to do. So here's the deal. So here's what we can do today. I can move off the bench and give the four of you a chance to speak about how to resolve this case. That would be a negotiation process. You're not required to do that, but I can certainly allow you to do that if you think that would be beneficial. I'll ask both sides whether they want to do that. If one side doesn't want to do it, that's fine. You don't have to. There's no requirement that you have to do that. But if you think that you can reach a reasonable, rational decision, then you don't have to make me make the decision. Because if I make a decision, typically somebody loses and somebody wins, and it may be you that loses. You don't know what I'm going to do. I may, for lack of a better term, split the baby. I may say they win on part of it and you win on part of it. I may say you don't get 60 days. You get 10 days because that's the normal amount of time. If you're going to move from the house, that's the normal amount of time to get out. And then you may still owe some money for that. There may be an offset. I don't know all of that yet. So that's one reason why you may want to negotiate. If you don't want to negotiate, then I'm going to take testimony from each side and listen to what the facts are. You'll be sworn, you'll be under oath, and you'll each be able to tell me what you think is right and what you think is wrong, and what you saw and what you heard. If you've got an estimate from Servpro, because they're not here, that would be called hearsay. That's a legal term that means you can't say what somebody else saw or heard. There are certain exceptions to that and certain limits on that, and that's the general rule. So you can only tell me what you know, what you saw, what you heard, what you did, kind of thing. Okay. Then each side is subject to cross-examination. So if Mr. Sereno testifies, this side would be able to ask him questions. And if you, ma'am, or you, sir, testified, Ms. Hostman or Mr. Sereno would be able to ask you questions. Once everybody is done, then you'll be able to give me an argument at the end that says, well, this is what the facts showed. This is what we think should happen. Now, you've told me a little bit about that already. And that helps me understand where you're going with this. So, Ms. Hostman and Mr. Sereno, do you guys want to engage in negotiations for a few minutes here before we do anything else?
We'll try negotiation.
Okay. And the Walshes, do you guys want to try negotiations to reach an agreement in this case? All right. I'm going to leave the deputy in here just to make sure that, and I don't think anybody's going to have any big problems, but he's not a part of the case. He's not going to tell me anything that he hears. He's just here to keep the peace. So you guys can sit where you're at. If you want to move the chairs a little bit, feel free to do that. We're going to take a break. I'm going to turn the equipment off so there's no recordings of anything going on.
Be safe, be well, sleep sweet, and much love.